All right, folks, this election year, the Supreme Court is working overtime with cases such as healthcare and immigration. In the next few minutes, we'll discuss what's next for the Supreme Court this year. Hello, everyone, and welcome to Comcast Newsmakers on the Vote. I'm Robert Trenum, and I'm joined by Stephen Vladeck, professor and associate dean at American University. Professor, welcome to the program.
Thanks for having me.
So this is a hot button year this year, 2012. You know, a lot of folks do not believe that the Supreme Court is political, but of course it's political. I want to talk about immigration first. This is coming to the Supreme Court because obviously Arizona's been in the national news. There are a lot of folks out there that says, first and foremost, this is a federal responsibility. States do not have the legal or the constitutional right to be able to police their own borders. Arizona has said, and other border states have said, well, the federal government is not doing their responsibility, so we have to step in. And the reason why we have to step in is because we're the ones that have to bear the burden as it relates to social services and so forth. How likely do you think that the Supreme Court is going to rule on this in partisan lines?
I think it's very likely that it's going to be a relatively partisan outcome. Certainly in high-profile immigration cases in the past, the court has split that way. But part of the partisan split here is also a split based on the relationship between the federal government and the states. The more conservative justices tend to believe more fervently in the idea of states' rights, in sort of more room for states to regulate, especially on areas like immigration. And so I think it is going to be a partisan split, but one that's informed by this deeper sense of who has more power in this field, the federal government or the states.
And of course, we know there's one justice that really is a swing vote. That is Justice Kennedy, correct?
Yeah, Justice Kennedy, you know, especially since Justice O'Connor retired in 2006, Justice Kennedy has really become the swing vote. Even though it's a nine justices are on the court, more often than not in these high-profile political cases, you tend to see the four more liberal justices on one side, the four more conservatives on the other, and Justice Kennedy, you know, swinging both ways depending on how he wants to rule in a particular case.
I want to move on to a topic that literally and figuratively is probably going to affect all Americans, and that is health care. It is a hot button issue, just like immigration, but probably a little bit more controversial just because of the whole mandate issue and whether or not that's constitutional or not. Of course, what I'm referring to is whether or not the federal government can force you to insure yourself. A lot of folks out there are saying no, the federal government cannot do that. A lot of folks out there are saying yes, and that is, I guess, the cornerstone, if you will, of the Obama health care law, if you will. What do you think is going to happen with this one? Man,
it's really hard to predict. You know, the Supreme Court's going to hear 6 hours of oral argument, which is virtually unprecedented.
That's a lot.
Certainly in the last half century. And it's going to come up in the end of March. You know, I think the justices are probably searching around to see if there's a way to solve this case without ruling up or down on the hot button constitutional question. At the core of this case is the Commerce Clause. Congress does most of its more controversial regulation through its power to regulate interstate commerce. The question is, for individuals who don't buy health insurance, are they in fact affecting interstate commerce by not acting? Congress found that, for example, in 2008, the federal and state governments combined spent over $45 billion on health care for those who weren't insured. And so the question is that enough in the Supreme Court's view to justify requiring all Americans either to have health insurance or to pay a penalty if they don't? I think that's the question the justices have to figure out, and I think their uncertainty about that may push them towards some narrower way out if it's possible.
And of course, an understory in all of this is Justice Kagan, who was the Solicitor General when health care was being debated in the U.S. Congress. There are a lot of folks out there, particularly conservatives, that says, you know what, she really needs to recuse herself because clearly she's inherently biased, because not only did she help write the law, she helped enforce the law when she was the Solicitor General. However, there are a lot of folks out there, including the Chief Justice, that says, no, she should be a part of this case.
Yeah, I mean, I think recusal is always a tricky question because it just so happens that the folks who are pushing for a particular justice to recuse tend to be on the opposite side of that justice's viewpoint. So just as there are calls for Justice Kagan to recuse in the healthcare case, there are also calls from progressives and liberals that Justice Thomas should recuse in light of statements that he and his wife have made publicly about the healthcare bill.
His wife is a very well-known, she's not a lobbyist, but she's a very well-known party activist.
That's right. And so, and I think the question is, you know, this goes back to your initial point about the justices as not being political. I think if we all accept that they have feelings and that they have fairly strong viewpoints, the question to me is not, you know, are we really unsure sure how Justice Thomas is going to rule on this case or on how Justice Kagan is going to rule on this case. The question is there some personal involvement that would make their involvement in the case unfair? That would
in other
make
words, a true conflict of interest.
That's right, and I don't think we've seen it on either side here. I mean, I think we've seen, for example, in the affirmative action case, Justice Kagan has recused, and I think that's a fairly strong indicator that she will keep her own counsel. And indeed, that's been the tradition on the court, that the justices decide for themselves when to and when not to recuse.
You know, it's interesting, Professor, you mentioned affirmative action, which is the last topic that I want to talk about. This is a very interesting case, and the way I understand, and please correct me if I'm wrong, a white student applied for admission at the University of Texas. Right. She was rejected in lieu of an African-American student, correct?
Mm-hmm. That's right, and the problem is that this Supreme Court in particular over the last 5 years has taken a far more aggressive view of affirmative action, especially race-based affirmative action, as its own form of racial discrimination. And so the concern is that just as we don't tolerate racial discrimination against historically persecuted minorities, we're also equally wary, at least according to this court, of racial discrimination in the other direction. Now, the big precedent here is the 2003 case involving the University of Michigan, Grutter versus Bollinger, and there the court held 5-4 that even though it was a race-based classification and should get the highest judicial scrutiny, that the law school policy actually survived because it used race as a soft variable. It didn't give applicants a fixed number of points because of their racial background. It didn't give them any clear in or clear out. The problem is not that the UT policy differs from the Michigan policy. The problem is that the court has changed. Justice O'Connor was the key vote in the Grutter case. She's been replaced by Justice Alito, who I think we can safely say is less sympathetic to that position. Justice Kennedy, who we talked about, is now the swing vote on the court, was in the dissent in the law school case in 2003. And Justice Kagan, as we mentioned, is recused. So the question is, where are the votes to uphold this policy?
And a lot of proponents would make the argument that this could be a chipping away, if you will, of affirmative action rights, for lack of a better term, overall.
I think that's right, and indeed I think a lot of folks would say we've already seen the chipping away. So there's the parents involved case from 2007 where the Supreme Court said Seattle and Louisville, for example, could not use race as a tiebreaker in secondary school assignments. So I think the concern is not just that this Fisher case might see more of a chipping away, but this actually might be the end of it. That now that the justices have what appears to be a 5-justice conservative bloc to vote against race-based affirmative action, we might actually see the court say the time has come to end this as a constitutional matter, even though I think many would say we're not there yet socially, we're not there yet culturally.
All right, Professor, we got about 45 seconds left. Immigration, healthcare, affirmative action, 2012. How do you think these three big issues are going to play in the national debate between President Barack Obama, the incumbent president running for re-election, and whomever the Republican nominee is?
I think the reality is, of the three cases we've been discussing, healthcare is the big one. You know, I think the immigration case, no matter what happens, it's a relatively regional issue in a part of the country where I think the politics are fairly well embedded. If the Supreme Court upholds the healthcare bill, I think that's an enormous victory for President Obama, and it would take a lot of steam out of whomever the Republican nominee is attacking the social agenda of the Obama administration. If the court strikes it down, I think that would only embolden the Republican opposition and make things even that much more interesting for the fall. You know, I think the other piece of this is to keep in mind, whoever wins the election of 2012, Justices Kennedy and Scalia will be 80 by the time their presidential term is over.
You're talking about maybe 2 vacancies, perhaps, at a minimum.
I mean, this is not, so I guess the point is this is not just about these three cases,
Sure.
right? This election is really about shaping the future of the court, especially if someone like Justice Kennedy, who is the critical vote in the middle, might retire sometime in the next 4 or 8 years.
To be determined. Professor Vladeck, thank you very much for joining us.
Thank you.
Really appreciate it. Of course, thank you for joining us for this edition of Comcast Newsmakers on the Vote. I'm Robert Tranum. Have a great day, everybody. We'll see you next time. Take care.